When I meet with the Tatalia people, should I insist that all these drug middlemen have clean records?
Mention it. Don't insist. Bazzini's a man who'll know that without being told.
You mean Tatalia?
Italia's a pimp. He never could have outfought Santino. But I didn't know until this day that it was Bazzini all along.
Like you, be strong to hold the powers of the sun.
It is the world that has been pulled over your eyes to blind you from the truth. I show you how deep the rabbit hole goes. All I'm offering is the truth, nothing more.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And get ready. Get ready for this one. We're going to be reading out of one of the new court docs. And this is one I've been waiting on for a long time, although I had no idea it was going to contain what it contained. But I'd been waiting for the defense. For those of you who've been following me for a long time, you know I said that at some point the defense would be filing a motion for sanctions to remove the death penalty because we need a jury to be seated that's not death penalty qualified, so they keep an open mind. And I thought they'd wait for the motion and sanctions to do it and then cite the Vallow case, and that would be their best chance to get it removed. Well, instead, they went with a motion to preclude the death penalty due to discovery violations. And I'm not so sure that if this one is not successful, that they won't still file a motion for sanctions to remove the death penalty due to lack of discovery, because none of the things that I expected to see in this motion are actually in there. And y'all know that I've kept a list of things that the defense has not received in discovery. One of them being the call detail records. And we know now that they never received the call detail records because the prosecution filed a motion in limine to exclude them, bringing up the fact that they never received the call detail records. Interesting. But also they never received the transcripts. The subpoenas for the grand jury warrants. They never received a lot of video, especially those videos that we really want to see, like Mundy's Machine, Wasankari Construction, and Gypsy Java, because those are all the videos that lead right into Wasankari Construction. But then I start to read what the defense has actually written in this motion to preclude the death penalty, and and it may actually pertain to everything that I just mentioned, especially those Wasankari Construction videos. Hold on to your hats, folks, and sit back and relax, because this is a long document. I'm not going to read the whole 30-page document, but I've highlighted quite a few things that I am going to read to you. I'm going to try to keep my commentary to a minimum and just read what the defense has written in their document or wrote in their document. And I am going to read out of one of the cases that they cite. And I don't think I'm going to have to add too much to this one. Let's go. Okay, we have defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. And it says the state has failed to provide expert disclosures that are specific enough to understand what testimony and discovery it intends to rely on. The discovery in this case has been provided in a manner that is as though the state took tens of thousands of documents, photos, and video clips and shook them up in a snow globe. While the defense counsel has made Herculean efforts to review the discovery provided, there is no possible way that all of the discovery, which is the equivalent to 68,000 copies of the Encyclopedia Britannica, can be reviewed prior to the trial date. Indeed, a defense expert informed counsel it would require 3 additional years to review all the discovery from the 67 electronic devices and digital data alone. As discussed in this motion, in cases with enormous amounts of electronic data, the prosecution does not meet that standard by providing discovery in a manner that effectively buries exculpatory, impeachment, and mitigation information. By the way, when she cites 68,000 Encyclopedia Britannicas, a single Encyclopedia Britannica contains more than 30 volumes. So a volume is just one book. So you take 30 volumes, is one Encyclopedia Britannica, and there's 68,000 Encyclopedia Britannicas. So you take 68,000, multiply it by 30, and that's how many books that it would take to be the equivalent of the discovery that the state has given them, and then not giving them any kind of direction with it. Mr. Kohberger requests that the court exclude evidence and testimony that the state has not yet provided in adequate expert disclosures. Mr. Kohberger acknowledges this motion requests preclusion of the death penalty as one of the remedies after this court's ordered deadline. However, good cause exists for this filing. The state has produced an enormous amount of disorganized data, continues to provide discovery past their deadline, and refuses to provide requested supplemental discovery, and has failed to abide by expert disclosure rules and order. What are they looking for? Well, Mr. Kohberger has been prejudiced by the state's failure to fulfill its disclosure obligations, and judicial remedy is required. Preclude experts and testimony not properly and timely disclosed by the state. So we want them not to be able to testify. Require the state to provide hot documents index of information it intends to rely on, as well as Brady Giglio evidence in accordance with the minimum standards for voluminous electronic discovery. Preclude the death penalty as a potential sentencing option. So that's what the defense wants. And then we'll get into the relevant factual background, and I won't go through all of it because it's talking about all the case law revolving around this enormous amount of digital data that they're not telling them, where to look in. And then you'll see it also says about that digital data. It also includes more than 60 plus digital devices and digital data and search warrant data, including cell phones and laptops from Mr. Kohberger, the victims, alternate suspects, and various other individuals who knew the victims. Whoa, so it contains all of this information, 13,000 photographs, 15,000 video clips, 8,000 video clips from residences, plus 60 plus digital devices. Some of them are from the alternate suspects. Yowza. As discussed below, the state has gained a tactical advantage that cannot be remedied now, and therefore this court must take affirmative steps to put Mr. Kohberger back on equal ground. Argument. Prosecution's discovery obligations under the federal and Idaho constitutions and Idaho law. Both the federal and Idaho constitutions, as well as Idaho law, require that the prosecution turn over any materials to the defense which may help the accused, either by negating the guilt, mitigating punishment, or impeaching the state's witnesses. Whoa, impeaching the state's witnesses. The prosecution has a constitutional duty to identify, preserve, and disclose exculpatory information. Accordingly, the state violates a defendant's due process rights whenever the state suppresses evidence that is material to guilt or to punishment, irrespective of the good faith or bad faith prosecution. We'll wonder what the state is suppressing in that evidence. What are they not giving you, Ann Taylor? The prosecutor's duty to produce this material is self-executing. She must turn over Brady material regardless of whether the defense has made a specific request. The good faith or bad faith of the prosecutor is not relevant to the Brady inquiry. Whether the non-disclosure was a result of negligence or design, it is the responsibility of the prosecutor. The prosecutor's office is an entity, and as such is the spokesman for the government. The duty exists even if the defense conceivably might have access to the information independently. See, e.g., United States versus Shaffer. Oh, we're going to take a look at United States versus Shaffer. Non-disclosure of government witnesses' paid informant status, not absolved even if defendant might have uncovered it through independent sources. Tapes disclosed to co-defendant, not effectively disclosed to the defendant because trial strategies of co-defendants often conflict. Oh my goodness. Why would she put United States versus Shaffer in there and then specifically point to this out of United States versus Shaffer? Why do you think? Who have we said is a co-defendant? Who have we said is a paid informant? And who did we say that she was trying to uncover the entire time? So we'll take a look at United States versus Shaffer, 789 F.2D, and just have a look and see what that says. But before I do that, here's something that I would like to go over with everybody. Just some of the finer points of my investigation, some of the major things. Now, of course, this is a fraction of what we've put together, but let's just look at these major things in my investigation that I've come up with, and then we'll just see how it relates to everything we're about to read in these documents. Number one, Brian Kohberger's innocent. Law enforcement got his name from Kopacka's phone. Number two, Brent Kopacka is also innocent, but he was set up for the atrocity by some people that did not like him and thought he would make the perfect patsy. Number three, Mr. Farley is either a lookout or a perp, but a main character involved in this event. And number four, Mr. Farley is the main informant in the case that gave up Kopacka. Number five, this whole thing started when the mother and father and stepmother informed on Farley and caused his arrest. Number six, Farley was working for the Aryan family and the Aryan Knights as a middleman/mule. Number seven, the Aryan family/Aryan Knights committed the atrocity, forcing Farley, I'm tentatively saying forcing Farley to assist. Number eight, the Aryan Knights used an insider, Mr. QK, the boyfriend of one of the roommates, and his girlfriend, one of the roommates, to complete the hit. Number nine, the AK has since tried to silence people through a prison break and extermination of family members of those who were in the know. Now, I could keep on going. We could get all the way into Gill and Slocum. We could get into Leonard. We can get into Kelly Farley, how they all relate. We could get into Farley's significant other, Miss Rhodes, and how she plays into this, along with Mr. Burroughs and Kopacka's girlfriend, Zagalo. We could get into all that, but I just want to give you just some major points right here. And as we look at these major points, let's just keep those in mind as we read the rest of this document. All right, so United States versus Shaffer, May 5th, 1986, 789 F.2D 682, Ninth Circuit Court. What is going on here, Miss Taylor? Let's see. Appealee William White Shaffer was convicted on several counts of narcotics and income tax violations. The district court granted Shaffer's motion for a new trial. concluding that the government's failure to disclose to Shaffer certain impeachment evidence regarding a government witness violated the rule set forth in Brady versus Maryland. The government appeals the district court's decision. We affirm the district court's order granting a new trial. Oh, okay, so the appellate court upheld the district court's ruling that he should get a new trial because of something regarding this government witness. Well, let's read on. Background. On September 16th, 1981, a grand jury returned a superseding indictment charging Shaffer and 3 other defendants with 4 counts of narcotics violations and 4 counts of income tax violations. The indictment alleged that from February 1975 to April 1977, the 4 defendants conspired to import and distribute cocaine. The other 3 defendants indicted were James Hoffman, Baron Bingen, and Joseph Howland. The government's case against Shaffer rested in large part on the testimony of Robert Durand, an unindicted co-conspirator in the cocaine operation. In May 1980, Durand, in exchange for immunity from prosecution, agreed to cooperate with the government in an investigation into the cocaine operation conducted by Shaffer and the other three defendants. During the investigation of Shaffer, Durand was paid for his expenses in a meeting with the IRS and DEA agents. In February 1982, Durand was also paid for expenses incurred in traveling to Los Angeles to prepare for Shaffer's trial. During the trial, Durand was also paid for security expenses, and after the trial, he was paid for security and relocation expenses. During the cocaine investigation, one of Shaffer's indicted co-conspirators, James Hoffman, contacted Durand about a separate heroin operation that Hoffman wanted to conduct. Shaffer was not involved in this new narcotics operation. With the aid of Durand, the government conducted a supplemental investigation into Hoffman's heroin operation from approximately September of 1980 to May 1981. During the Hoffman investigation, the government compensated Durand for expenses incurred in meeting with Hoffman. Durand also received money that he paid to Hoffman and another subject for their expenses in setting up the smuggling venture. Therefore, while Durand was testifying in the Shaffer grand jury proceedings, he was also operating as a paid informant in the Hoffman investigation. Before his trial, Shaffer made a specific discovery request concerning any promises that the government made to Durand in exchange for his cooperation. Durand's tax returns for the time period charged in the indictment, internal government memoranda regarding Durand's cooperation. Shaffer also made a general request for all material in the government's possession that was favorable and material to his defense. In response, the government provided Shaffer with a copy of Durand's grand jury testimony and Durand's immunity agreement. The immunity agreement provided, in essence, that the government would not prosecute Durand for any of his criminal activity in the Shaffer narcotics operation. Any information provided by Durand would not be used by the government against him except in a prosecution for perjury. Hey, this is a Rule 11 agreement, y'all. And Durand would not be subject to any criminal tax prosecution through the calendar year 1981. But the U.S. Attorney would nonetheless notify the IRS about any information relative to any civil audit or investigation of Durand. The government stated that this immunity agreement was the complete agreement with Durand, and no separate, secret, or other agreement was made with Durand. At Shaffer's trial, Durand implicated Shaffer in the cocaine operation. Durand testified inter alia about the smuggling trips conducted by the conspirators and the enormous profits realized by Shaffer and the others on the cocaine operation. On May 7, 1982, a jury convicted Shaffer of all 8 counts. Approximately 2 years after his conviction, Shaffer filed a motion for a new trial, pursuant to Fed R. Crim P. 33, based on newly discovered evidence. As a result of evidence revealed at an evidentiary hearing on this motion, Shaffer contended that the government failed to disclose to him prior to trial that Robert Durand was a paid informant in Hoffman's separate heroin operation during the years 1980 and 1981. The full benefits and expense payments that Durand received in exchange for his cooperation in both narcotics investigations, the full extent of assets which Durand acquired through narcotics profiteering, and the fact that the government has failed to initiate any civil tax proceedings against Durand. Shaffer argued that these facts, if used at trial, would have had a substantial effect on Durand's credibility and would have resulted in Shaffer's acquittal. On February 14, 1985, the same district court judge who presided over the trial granted Shaffer's motion and ordered a new trial. The district court held that Durand's testimony was critical to Shaffer's conviction. And if the jury chose not to believe Durand, it is quite possible that Shaffer would not have been convicted. The district court further held that the information revealed in the evidentiary hearing, if used at trial, creates reasonable doubt that would not otherwise exist, and certainly creates the reasonable possibility of material effect on the jury. So, let's just sum this up, all right? Shaffer is a informant, and he was working dual investigations, and he was getting all kinds of wonderful deals and allowed to profit from the operations that he was informant on. And then the prosecution in his case failed to disclose all of that to the defense, so he was granted a new trial. Does that sound familiar to Pavarotti's investigation into the Idaho 4, y'all? Excuse me, United States versus Shaffer, that was pretty interesting. I wonder why that's applicable to this Koberger non-disclosure case. Is there any other details that, what is this? Mitigating evidence is material when it may well have been consequential to a jury's deliberations on punishment. In death penalty cases, Brady includes information that may not exculpate, but that nonetheless mitigates punishment. See Cone versus Bell. Remanding for resentencing so jury could consider suppressed evidence relating to defendant's drug addiction. As a result of an honorable military service. Who has a drug addiction as a result of an honorable military service? Wonder if that's applicable. Vacating Cone's sentence because the cumulative impact of the missing witness statements, police teletypes, interview notes regarding Cone's drug use may well have been material to the jury's sentencing deliberations, even though they were not material to the insanity defense in the guilt-innocent phase. Wonder if that doesn't apply to the co-defendant in the case. The obligation to disclose exculpatory evidence extends beyond what the prosecutors are personally aware of and beyond four walls of a prosecutor's office. It applies to federal law enforcement officers, state lab technicians, and other state actors. The duty of disclosure enunciated in Brady is an obligation of not just the individual prosecutor assigned to the case, Bill Thompson, but of all the government agents having a significant role in investigating and prosecuting the offense. So what you're saying there is if the FBI had, say, a confidential informant that they were working with, then it would not be okay for the local prosecutor to keep that information from being disclosed to defense counsel just because it is not his agency. It's a federal agency. Is that what you mean by that? I believe it is. Therefore, a prosecutor's Brady obligation extends to exculpatory information obtained or possessed by any federal or investigative agency with involvement in a case, including the Federal Bureau of Investigation. reversing death penalty conviction for prosecution's failure to disclose forensic crime lab worksheet showing possible drugs, which could have affected defendant's mental state, even though prosecutor had no actual knowledge of the worksheet. Whoa, I don't think they're talking about Kohberger right there, folks. I believe they're talking about BK with an L. Prosecutor will be deemed to have knowledge of and access to anything in the possession, custody, or control of any federal agency participating in the same investigation of the defendant. The probation departments? Kohberger wasn't on probation. Crime labs? And reversing death penalty conviction for prosecution's failure to disclose forensic crime lab worksheet showing possible drugs and which could have affected defendant's mental state, even though prosecutor had no actual knowledge of the worksheet. What is this all about? Okay, well, C State versus Gardner, holding that a prosecutor violated Brady and ICR 16A, even though he was personally unaware of an exculpatory witness statement made to police. Whoa, who made an exculpatory witness statement to police that the prosecutor may be personally unaware of? Is that something that was said to the police during his SWAT assassination? I'll go through a lot of stuff here. Is there anything else? Oh, what is this? As such, the contents of all of the 67 electronic devices, digital data, and search warrant returns seized in this case contain enough information to paint a portrait of the daily lives of Mr. Kohberger, the victims, witnesses, alternate suspects, and people close to the victims. Given that the state's case is almost entirely circumstantial against Mr. Kohberger, patterns of evidence that emerge out of these devices may be key to a jury's consideration of guilt or innocence. So basically what she's saying right here is they can take all the information out of the devices and create a circumstantial, story that could paint anybody guilty. Courts often describe evidence regarding potential alternative perpetrators as classic Brady material. New evidence suggesting an alternate perpetrator is classic Brady material. Oh, got some new evidence, do they? Withholding knowledge of a second suspect conflicts with the Supreme Court's directive that the criminal trial, as distinct from the prosecutor's private deliberations, be preserved as the chosen forum for ascertaining the truth about criminal accusations. Regardless of the state's ultimate conclusions about whom to prosecute, withholding knowledge of a second suspect conflicts with the Supreme Court's directive that the criminal trial, as distinct from the prosecutor's private deliberations, as the chosen forum for ascertaining the truth about criminal accusations. What do you mean? Is this prosecutor withholding knowledge of a second suspect? And what in the heck? Oh, by the way, this one right here doesn't have a parentheses around it. This is just an actual statement from Ann Taylor. Countless cases have been overturned due to prosecutors' failure to timely produce evidence that could have helped the defense identify potential alternate perpetrators. Finding that prosecutors violated due process rights under Brady by failing to disclose the complainant's statement that it was possible he had misplaced a stolen ring. Finding that prosecutors violated Brady obligations by failing to disclose to bank robbery defendant fact that other nearby banks had been robbed after her arrest, and that a woman had been detained with uncanny similar physical description. Weird. holding that despite eyewitness identification of defendant, prosecutors violated Brady by failing to disclose to the defense of a potential alternate perpetrator with similar appearance. Who looks similar to Brian Kohberger? Oh my goodness. Is it Mr. BLK? Finding Brady violation in a second-degree murder case due to the state's withholding a police report that corroborated the defendant's version of events and supplied a motive for a different person to commit the offense. Finding that the prosecution violated Brady by failing to disclose police reports identifying alternative suspects. Whoa, police reports identifying alternative suspects. Those aren't frat boys, are they? Because many of these devices belong to the witnesses, the victims, and to people who knew the victims, including potential alternate perpetrators, defense counsel is plainly obligated to review them. Of course, there is significant additional discovery which is likely to contain exculpatory evidence relating to alternative perpetrators. For example, the defense had to fight for several thousand tips collected by law enforcement tip lines. Though they were in the state's possession the entire time, the state did not turn them over until more than a year after the case began. The defense has no way of knowing whether the state intends to rely on or introduce any evidence from those tips, and has never received a log of Brady Giglio evidence that the state has identified in the records. Whoa, they never received a log of it, huh? Because there is no log, an exact number is unknown, but the number of tips is more than 45,000. Tips continue to be reported. Whoa, I wonder where those tips continue to be reported from. Maybe some of my folks. In recognizing the large number of individuals sentenced to death who were later exonerated because they were innocent, 110 when the ABA guidelines were written, though the number now stands at more than 195. That's a lot of people that were sentenced to death that now have had their convictions overturned. This is a case where the facts are in great dispute. Mr. Kohberger asserts his innocence. There is no confession. There is no video. There's no audio of the crime. There's no weapon. There is only trace evidence on a movable object, a knife sheath. Having full knowledge of the state's expert opinions and documents they will rely on will provide leads for further investigation to uncover exculpatory evidence or to impeach prosecution witnesses. Explaining a case in which, from a joint capital trial, one co-defendant was eventually executed because his counsel failed to object to women being excluded from the jury, while the other co-defendant's case was reversed, and he is now serving life in prison because his attorneys preserved the issue. In a case as complex as this one, even assuming the state discloses detailed expert disclosures and an index of hot documents tomorrow, counsel will need the remaining months before trial to conduct independent investigation into the evidence and witnesses, identify evidence that contradicts the state's theories, and incorporate all of the new information into the defense's case. Finding that the state suppressed exculpatory evidence by identifying an eyewitness days before trial, such as the attorney could not reasonably be expected to suspend other trial preparation to interview the witness, and thereby constituting a failure to make sufficient disclosure in sufficient time to afford the defense an opportunity for use. As discussed above, evidence pointing to a possible alternate perpetrator or anything refuting the state's theory is bedrock Brady evidence and should be included. She wants that information now. Examples of this evidence in a capital case include evidence that a capital defendant was a devoted and loving family member, that he experienced trauma, neglect, isolation, or was ostracized as a child, young adult, or adult, that he excelled in his education, that he experienced blows to the head or other potential brain injuries, that he experienced depression, anxiety, and other symptoms of mental illness, that his symptoms began before he was charged with capital murder, and or that he is susceptible to pressure, manipulation, or exploitation. They are not talking about Brian Kohberger right here, folks. Another Idaho trial court recently concluded that precluding the death penalty was the only way to cure the prejudice of disclosure violations by the state. Bam, Lori Vallow Daybell. The state had Bates stamped and previously provided more than 80,000 documents in discovery. However, the prosecution failed to turn over approximately 5,000 pages of discovery and 30 hours of audio files until a month before trial. The court ruled from the bench and signed an order. This is notably many multitudes less than the 68 terabytes of discovery turned over in this case. Though the prosecution filed the discovery only one day after the deadline set by the court, the defense argued that there was insufficient time for counsel to review the significant discovery in a meaningful manner and complete any necessary follow-up prior to the trial 1 month later. The court agreed and found that dismissal of the death penalty was appropriate in order to mitigate the prejudice. Lori Vallow's motion to dismiss death penalty beginning 2116, the court specifically found that the state had acted in good faith and attempted to disclose all discovery, and that the remedy was not in any way intended to be a sanction for bad faith or misconduct by prosecutors. However, the court specifically noted that death is different, that heightened standards of reliability and unique safeguards must apply in a death penalty case, and therefore striking the death penalty was the only appropriate remedy. This court has commented in other proceedings related to, she even cites it, Kohberger's trial setting and motions about discovery and expert opinions, that Lori Vallow's case is distinguishable because she had not waived her speedy trial rights. Y'all all remember us going over that in detail. However, in this case, it is the court that is repeatedly telling all counsel and Mr. Kohberger the trial date is set in stone, and everybody must be ready to proceed by July 30th, 2025. So, Judge, you're the one doing that. In another case, a federal district court precluded the government from seeking the death penalty for 2 defendants after the prosecution failed to turn over some of the statements made by a witness for approximately 1 year after the defendants had been arrested. Now, there's no cases and law cited on that. That's a straight up statement out of Ann Taylor's mouth. And why would she say in another case, federal district court precluded the government from seeking the death penalty for 2 defendants after the prosecution failed to turn over some of the statements made by a witness for approximately 1 year after the defendant had been arrested? That's because Ann Taylor has now found the dead gum evidence that she needed to show that the confidential informants told about Brian Kohberger before they got back that stupid IGG. And she is hammering it home before she puts it in an open document. That's what you call, you better freaking rule the way I want, or I'm going to expose this situation to the public. And you don't want that to happen there, university. That's exactly what that is. That is a do it or else. And why is all this so important? Is it because Kohberger's guilty? No, it's because of this. Precluding the death penalty is therefore necessary to enforce Mr. Kohberger's constitutional rights. This remedy will also reduce the significant risk of seating a conviction-prone jury that does not hold the prosecution to their burden of proof, a fact that would exacerbate the state's already gained strategic and resource advantages, though a risk will remain that the extensive and prejudicial pretrial publicity from the mainstream morons and the other idiots on social media that can't openly think for themselves will negatively impact the fairness and accuracy of the jury's fact-finding. This risk will be mitigated when it is not compounded by the process of the death stupid qualification, a process that skews the jury towards conviction and death during voir dire before a single piece of evidence has ever been presented. Mr. Koberger hereby incorporates all arguments and authorities contained in this motion to prevent death qualification of the jury. That's why it's so important. But now everybody out there that wants to think I am crazy when I talk about the confidential informants and the co-defendant can all get on board now, because I think it's all but proven, isn't it? But that's not all. You know, out of nowhere, the state has gone, oh no. And they hurried up and they filed something real quick. And it's weird that it happened right as all of this stuff comes out about the alternate suspect defense and that motion to preclude the death penalty, that the defense just slapped right in their face with all that information. So how does the state respond really fast? Well, they file a motion to extend the protective order. Right, so they've been a protective order on the victims' families in this case from the beginning so that the defense couldn't speak to them. They were under protective order. Well, who did they extend that protective order to all of a sudden when all this stuff starts to happen? Kind of strange. Okay, so look at this. Dated the 6th day of March, 2024, just 2 days ago. I wonder why they hurried up and did this one. William Thompson. Motion to modify no contact order. The state of Idaho, by and through Latah prosecuting attorney, moves this court for a modification to the no contact order previously filed herein, prohibiting the defendant from having any contact with the father of one of the victims, pursuant to Idaho Code 18920. This motion is based on the fact that the father has requested the addition of his wife and stepdaughter to the no contact order. This is a no contact order from the defendant contacting them, not from anything else. So the father of one of the victims now wants the addition of his wife and stepdaughter. You think the father wants that? Or you think William Wofford Thompson Jr. wants that? Now, the state has contacted the defense attorney, Ann Taylor, in this matter, and she doesn't have an objection to amending the no contact order to include the wife and stepdaughter. That's because she already knows she don't need to talk to her. And we know who the wife and stepdaughter of the father is, right? Now, why would that be of importance right now? You know, it's really strange. No matter how many times I try to research why would a judge issue a no contact order for the victims' families from the defendant in Idaho, I can never really get an answer that makes any sense. That's something, if you'd like to do in your spare time, try to figure out why the judge would issue a no contact order, because when you look it up, it really, I can't find anything about the, defense attorney contacting them. It's just a defendant. So, I mean, I don't think Koberger has access to even, he might have access to a phone. I guess he could call them or maybe write them a letter or something, but I don't even know if he could do that. But everything about no contact orders, prohibit the defendant from having contact with them. So I can't really figure out. I guess maybe if I looked hard enough, it'd say the defense attorney can't contact them either, but I don't know. That was perplexing to me. That's about the only thing perplexing to me, though, in this case. After what I just read to you, I know I'll get a ton of guilters jumping in there on this now because, in their mind, they're hearing these words. Don't believe your lying eyes. That's what they want you to do too. Don't believe your lying eyes and ears. When you see and hear something, just don't believe it. I have trouble not doing that. When I see and hear something, I tend to believe what my eyes and ears hear because I've got eyes to see and ears to hear. And I know a lot of you do too. Please like and subscribe to the channel. Post your comments, thoughts, criticisms, and until probably late tomorrow night, Pavarotti's out.
Fly away. It's the first time